Take a factual scenario from a law exam. Hotel owner Andy hires a plumber who leaves a deep hole exposed. Rushing guest Desmond falls in, breaking his pelvis and spectacles. The plumber is insolvent. Andy points to a warning sign denying all liability. To determine if Andy is liable, you cannot rely on general common law negligence. Claims involving injuries on someone's property are governed by a strict dual-track statutory framework. Those two tracks are the Occupiers Liability Act 1957 and the Occupiers Liability Act 1984. We are going to deconstruct the Andy and Desmond scenario using the IRAC method, issue, rule, application, conclusion, to identify exactly where liability falls. In a tort exam, guessing who is at fault earns 0 marks. You must prove liability by applying the facts to the specific sequential requirements of the law. The first legal issue to resolve is establishing the defendant's status. Is Andy legally the occupier for the purposes of the acts? The rule, established in the case of Wheat v. L. Lacon & Co. Limited, dictates that ownership of the property is irrelevant. The test is whether the defendant has a sufficient degree of occupational control over the premises. Because Andy runs the hotel and directs operations in the lobby, he possesses the required occupational control. He is the occupier. The second preliminary issue is the scope of the danger. Both acts explicitly state they only cover dangers due to the state of the premises. This means structural or physical defects. It does not cover injuries caused by an occupier's activity. In Revel v. Newberry, an occupier fired a shotgun through a door and hit a trespasser. The court ruled the acts did not apply because firing a gun is an activity, not a physical state of the building. It also excludes injuries resulting entirely from the claimant's own conduct. In Tomlinson v. Congleton Borough Council, a man dove into a shallow lake and broke his neck. The shallow water was obvious. The danger arose from his decision to dive. Here is an absolute rule for exams. If the injury is activity-based or caused solely by the claimant's conduct, you must shift your analysis away from the statutes and rely on common law negligence. An exposed hole in a marble floor is a physical defect. It is a danger due to the state of the premises. Andy has occupational control, and the danger is structural. The threshold is cleared, and the statutory requirements apply. Next, we determine the claimant's legal status. As a paying hotel guest, Desmond has express permission to be in the lobby. He is a lawful visitor, which means his claim is governed by the 1957 Act. Under Section 2.2 of the 1957 Act, Andy owes Desmond the common duty of care. Note the phrasing carefully. The statutory duty is to see that the visitor will be reasonably safe, not to guarantee the premises are perfectly safe. This brings us to the core complication. Andy did not create the hole. Charles the plumber did. Can Andy discharge his legal liability by blaming an independent contractor? Section 2.4b provides a defense if the occupier passes a 3-part test. First, was it reasonable to entrust work to a contractor? Second, did they check competence? Third, did they check the work was properly done? Legal analysis almost always hinges on that final requirement. In Hazeldine v. Daw, courts ruled a landlord couldn't be expected to check complex hydraulic lift repairs. It was highly technical. But in Woodward v. Mayor of Hastings, a school was liable when a cleaner left icy steps. Identifying ice requires no specialist knowledge. Applying this to Andy, checking if an open hole in a busy hotel lobby has a physical barricade around it requires 0 plumbing expertise. Andy simply failed to check non-technical work. The conclusion is clear. Andy has failed the independent contractor test and is in breach of his common duty of care to Desmond. An occupier can delegate a job to a professional, but they cannot delegate their legal liability if the resulting hazard is obvious to a layman. Now, let's alter the facts. Suppose Desmond is not a guest. He is a pedestrian who ignores a no public right-of-way sign to take a shortcut through the hotel to avoid the rain. The legal consequence is immediate. Desmond's status shifts to trespasser. The 1957 Act ceases to apply, and the Occupiers Liability Act 1984 takes over. Under the 1984 Act, the duty of care is not automatic. It is conditional. Desmond must satisfy 3 criteria under Section 1.3. First, Andy was clearly aware of the hole. Second, Desmond must prove Andy knew trespassers were in the vicinity. Third, it must be highly reasonable to offer protection by putting up a simple partition. Even if the criteria are met and a breach is established, the 1984 Act strictly limits the scope of compensation. Section 1.8 states the duty is owed only in respect of personal injury. Property damage is entirely excluded. If Desmond is a trespasser, his broken pelvis is actionable, but the broken spectacles are his own financial loss. Crossing a physical or permission-based boundary immediately shifts a claimant's legal protection from automatic care to conditional safety. Returning to our original facts, with Desmond as a lawful visitor, we must address Andy's final shield, the warning sign at the reception desk. Section 2.4a of the 1957 Act permits an occupier to discharge their duty by adequately warning visitors of a danger. However, an apology for inconvenience caused by repair work is too general. It does not sufficiently alert a visitor to the specific, hidden danger of an open hole. Evaluated purely as a warning, the sign fails. But the sign also states the hotel accepts no responsibility for any injury, loss, or damage. This is an exclusion of liability clause. Analyzing this requires stepping outside of tort law entirely and applying statutory contract controls. The Occupiers Liability Act is subordinate to two massive regulatory statutes, the Unfair Contract Terms Act 1977 and the Consumer Rights Act 2015. Since Andy operates a commercial hotel as a trader and Desmond is a consumer, the CRA 2015 governs. The CRA establishes an absolute limit. Any attempt by a trader to exclude liability for death or personal injury is void by law. Andy's sign cannot protect him from paying for Desmond's broken pelvis. Excluding liability for property damage, the spectacles, is permitted, but only if the sign passes a strict statutory fairness test applied by the courts. Andy has one final partial defense: contributory negligence. Desmond was running through a lobby, carrying a heavy bag, while repair work was visibly taking place. Andy is ultimately liable for the breach of his duty, but the final financial damages awarded to Desmond will be reduced proportionally by the court to reflect his own carelessness. The claimant's status dictates the act dictates the duty. External statutes dictate the exclusions. Mastering occupiers' liability requires ignoring vague arguments about what is fair. It requires executing a precise sequence of steps to locate the exact point of legal failure.